Good afternoon, one and all. For the afternoon session of paper presentations for the International Research Conference on Insolvency and Bankruptcy, we have our esteemed panelists, Dr. Aparna Ravi. She is a partner at Samvad Partners, and Dr. Sri Ritesh Kavdia. He is the executive director at IBBI. So just to lay the rules about how this is going to work, we have 4 paper presentations for the day. For this session, each paper presentation would be timed for 17 minutes, and we would have a 5-minute question-answer session. And we ask everyone to stick to the time limits. So the first paper presentation for this session the topic is IBC, Balancing Fairness and Equity. It would be presented by Ms. Pooja Singla and Mr. Vinay Pandey. Over to them.
Good afternoon, everyone. We are 2 authors and we are presenting the paper on IBC, Balancing Fairness and Equity. So the objective is very clear that for any law to be effective, the processes must be fair and equitable for all the stakeholders. And in context of IBC also, this has been said time and again in various committee reports. If we see the Bankruptcy Law Committee report, which is the foundation of IBC, it has provided that a collective mechanism for resolving insolvency should be within the 4 corners of fairness and equity for all the stakeholders, and it is one of the hallmarks of a well-developed insolvency regime. Also, the creditor rights have been given utmost importance. Also, the World Bank Principles for Effective Insolvency and Creditor-Debtor Regimes has recommended that the creditor and trust should be safeguarded and by the appropriate means so that they effectively monitor and participate in the insolvency proceedings, as this is necessary to ensure fairness and integrity in the entire process. Then we have UNCITRAL legislative guide on insolvency, which has also noted the importance of impartial resolution of insolvency and the preservation of insolvency estate to ensure equitable distribution of assets among the creditors. Lastly, we have a report of the working group on outcomes under the Insolvency and Bankruptcy Code, which has suggested a 3E framework for measuring outcomes of the code. The first E is effectiveness. It's a measure of the extent to which the insolvency system has achieved its intended objectives. The next E stands for efficiency, a measure of the extent to which the system has achieved its objectives with the minimum use of resources. And the third E stands for efficacy. It's a measure of the extent to which there exists some connection between the insolvency subsystems with the larger macroeconomic variables. So we'll talk about the first E, that's effectiveness. And for any process to be effective, it should be fair and equitable for all the stakeholders. So in this paper, we'll analyze 8 broad areas of the code where we feel that some intervention is required. We would like to state that this is not a data-driven paper, but we have analyzed the legal jurisprudence that has been emerged around these areas. So the first area that we are analyzing is the verification of claims in resolution versus liquidation. Before we go into the provisions, it is important to understand the importance of claims in the resolution process. If we see the first point, the committee of creditors is formed on the basis of list of creditors that is prepared by the resolution professional. And it is the committee only which decides the fate of the corporate debtor, whether to give it a new life or to let it die. Next is that information memorandum is also prepared on the basis of list of creditors and the claims that has been verified by the resolution professional. And information memorandum is one of the instruments to give information to the resolution applicants. And in one of the judgments, it was held that information memorandum and the resolution applicant must know exactly what has to be paid in order to take over the business of the corporate debtor. And that information can be provided by way of information memorandum. So it plays a very crucial role. Another important point to note is that resolution plan is prepared on the basis of list of claims that has been prepared by the resolution professional. And we know that the resolution plan is binding on all the stakeholders. So the claims that are not considered in the resolution plan gets extinguished, which shows that the list of claims and the verification plays a very crucial role. We are also aware of the objectives of the code, which is resolution, and liquidation is considered only as a last resort. But if we see the powers that have been granted to resolution professional versus what have been given to liquidator with respect to the claims, RP can only collate the claims, whereas liquidator can accept or reject the claims. It has been clarified by NCLAT and Apex Court time and again that role of RP is only administrative, and it has no domain to accept or reject the claims. While we also note that there is no practical difference between the role that IP or liquidator plays, but the only difficulty that we are facing is due to the lack of provision empowering the resolution professional to accept or reject the claim. And this leads to unnecessary delays in the entire process, because then the creditors file interim applications before the courts against the non-consideration of claims by the resolution professional. Now the question comes is, keeping in mind the objective of the code being resolution and liquidation considered as a last resort, is it fair to limit the powers of resolution professional to only collation of claims while giving the power to liquidator to admit or reject the claims? So what we have suggested in the paper is that RP should also be empowered to make quasi-judicial determination of claims in line with the powers that have been granted to the liquidator. And also there should be mandatory timelines for filing of appeals against the rejection of claims by the resolution professional. Our next broad area is powers and duties of committee of creditors. Under the code, the committee plays a very crucial role in the entire process. It's considered as a supreme decision-making authority, whether to decide the resolution or liquidation, or whether the replacement of resolution professional. It needs to exercise also the commercial wisdom to decide on the approval of resolution plans. So given the powers that have been granted to COC under the code, the objectivity of the COC in decision making and its ability to best serve the interest of the stakeholders is as important as the rescue of the corporate debtor itself. So when we bind the resolution professional by a well-defined code of conduct, and it is continuously regulated and monitored by the regulator, so why not COC, in the hands of which the ultimate goal lies, is not monitored or regulated? Also, the Apex Court has held in various judgments that the adjudicating authority cannot question the commercial wisdom of COC. The Bankruptcy Law Reforms Committee also noted that judicial intervention should be kept at its bare minimum. It was to reduce the judicial delays which were prevalent in the earlier laws. So in that case, a well-defined code of conduct for COC becomes even more important. What we have suggested in this area is that there should be an appropriate code of conduct for COC members, which may include principles such as transparency, prior due diligence, disqualification for misconduct, and to balance the interest of all the stakeholders. We also know that IBB has already released a discussion paper on the need for code of conduct. So our suggestion in this area supplements what has already been said in the discussion paper, and which has been highlighted by the Standing Committee on Finance. Our next broad area is resolution versus liquidation, what suits whom. So as we discussed that the decision of resolution or liquidation lies in the hands of COC, and COC can even decide for liquidation at the first day itself. If we see the process in the resolution versus liquidation, there is no set distribution order in the resolution, but when it comes to liquidation, there is a predefined order which we call a waterfall, where we give priority to the secured creditors over other creditors. And the government dues rank last in that. So there can be certain situations where the creditors would prefer liquidation over resolution. For example, if the resolution value is very close to the liquidation value, so the secured creditors may want to push the company into liquidation, because in resolution there is no standard order for distribution. The resolution value can be allocated among the creditors in any order. We also call insolvency professionals as one of the 4 pillars of the code, but the professional has no say in the entire resolution process, and no opinion of that professional matters. Only they have to study the resolution plans, confirm that it is within the requirements of the code, and place it before the committee of creditors. So the question that arises is, can we achieve the objectives of the code, which is resolution and which is to balance the interest of the stakeholders, by just relying on the commercial wisdom of COC? The only logical statement behind what we are suggesting is that we cannot expect a particular beneficiary of the process to think about all other beneficiaries and to think of their interest. So what we are suggesting it's very important to have an independent sight over the entire process. We can cast a duty on the resolution professional to oversee the entire process and to ensure the value maximization by securing the maximum resolution value and to ensure the equitable distribution among the creditors. Also, there is need of legal intervention in the code where the insolvency professional should form his opinion on the resolution plans before passing it on to COC, and that opinion should also be taken on record before the NCLT while approving the resolution plans. Our next broad area is the treatment of provident fund and other similar dues in liquidation versus resolution. So one of the core objectives of the code is to balance the interest of the stakeholders, and this area is with respect to workmen and employees as one of the key stakeholders of the process. The claims that are filed by the workmen and employees, that includes various components, which includes the salary component, gratuity, provident fund, pension fund. So what we'll be discussing here is the differential treatment of these kind of claims in liquidation versus resolution. And even within liquidation, there is no settled law. If we see the liquidation process, the ranking is clear in terms of where the workmen and employee dues stand, and also in terms of preservation of gratuity fund or pension fund by keeping it outside the pool of liquidation estate. But if we see some of the conflicting judgments by NCLT and NCLAT, in one of the judgments, it was said that if the funds have not been created by the corporate debtor in a separate account for pension fund or gratuity fund, even then, these dues are the assets of the workmen and employees and are outside the purview of the liquidation estate, because these are the third-party assets owned in the possession of the corporate debtor. Another judgment by NCLAT says that liquidator has no domain to deal with the assets of the corporate debtor, which are not part of the liquidation estate. So if the funds are not maintained in a separate account, liquidator has no power to keep the money aside. Unlike liquidation, there are no similar provisions in case of resolution. The claims of employee provident fund organizations can be considered as government dues, according to one school of thought, which comes nowhere in the resolution plan, as we have seen in most of the resolved cases. And then there is another view, which says that dues should be paid in priority to all other dues, keeping in mind the welfare of workers and the Provident Act provisions, which says that the claims of employee provident fund organizations shall have the first charge over all other dues. Also, a recent judgment by NCLAT says that there is no conflict in the provisions of Provident Fund Act and IBC, and it also directed to pay the Provident Fund dues in full. So what we're trying to say here is that PF and other dues are social security schemes of the state, and these dues should have preference over all other dues. In one of the EPFO cases, it was said that workmen all through their life save some portion of their hard earnings for the later part of their life after retirement. If such sums are being interlinked on par with debts of the creditors of the company, secured or unsecured as the case may be, then it is nothing but diluting most valuable and alienable right of a person on par with a property right subordinate to right to life. So as we have set jurisprudence and set provisions under the Provident Fund Act, where the employee dues are given supreme importance, unfortunately the same principle has not been followed in the code. Categorizing them as operational creditors attracts nothing but only the liquidation value, which is almost nil in most of the cases. So our suggestion is the hard-earned money of the workmen and employees, as is saved in liquidation, should also be saved in case of resolution. With this, I would like to hand over to my colleague, Mr. Vinay, for taking through the next slides. Thank you.
Thank you, Pooja. Our next issue is the fee of RP versus fee of liquidator. Section 530 of the IBC includes the fee of RP as a CRP cost and means that the fee shall be decided by the COC. However, the code does not provide any criteria for deciding that fee. There is a clause 25 of the Code of Conduct which says the fee should be reasonable. And in view of that, IBBI has issued a circular which provides what the criteria for deciding this reasonableness. On the contrary, the fee of liquidator is either decided by the COC or as per the matrix provided in the liquidation regulation. The matrix is derived in such a way that the maximum fee is provided for the allocation distribution of asset in the first 6 months. So this is a type of success fee for the liquidator. Now, can it be said justifiable that a liquidator is giving the fee on the basis of distribution of the asset, while in the fee of RP there is no concept of success fee, or we can say the fee of RP is not have any link with the resolution value provided in the resolution plan. This issue is more problematic because during CRP, the scope of work, that is verification of claims, preparation of IM, then evaluation of plans, the evaluation metrics. These all are very complex in nature, and it is very difficult to quantify them. The second issue, the fee during this CRP is decided by the COC, and COC is not always consist of the commercial bank. There are instances where the COC is consist of the home buyers or the OCs or the or the FCs which are not institutionalized, so they are not enough mature enough to decide the quantum of the fee. And third and last most important aspect, the RP makes every possible effort to stripe the CD back into the resolution. So in our view, he should be more, means we should be more considerate while deciding his fee. So with this, our one suggestion is that there should be some sort of reward for the RP, or in the line of the liquidator, I mean there's some sort of success fee for the RP. The second issue is the extent of procedure fairness as well as judicial review involved. Now, any business activity of the CD normally comes under the purview of more than one law. So there is always a link, or there is always a connectivity between insolvency law and others law. Even this interrelationship among IBC and other law is being very well defined in the Insetral principle, which says, I am quoting unquote, the relationship between insolvency law and other law should be very clear, and where possible, references on the other law should be included in the insolvency law. Now, IBC is normally silent about this interrelationship, especially in context of the resolution plan submitted by the resolution applicant. So, what is happening? Resolution plans contain so many waivers or concession reliefs that are not even in the authority of NCLT to grant these relief. So the problem is more aggravating because different NCLT have different approaches regarding these waivers. Some NCLT granting this waiver, while some NCLT just passing the conditional plan that we are approving the plan, but we are not giving you these waivers. In this regard, there are two provisions under the code which deal with this interrelationship. First is section 32, which said that the plan should not in contravention of any other law for timing in force. And second, section 31.4, which says that after the approval of the plan, resolution applicant shall take approval of the approved authority within 1 year of the approval of the plan. So we have two considerations here. First, whether these waivers or these concessions can be granted, and if they granted, who should be the authority for granting these waivers. So even we have noticed that sometimes the applicant seeks waiver that are not even relevant for the operation of that CD. Recently, even NCLT Ahmedabad in the SBI versus Metal Ispat Limited has observed that we are, I am quoting the verbatim, the NCLT, we are however constrained to observe that many of the waivers, relief and concessions outs are without any application of mine. These have been routinely observed in previous cases involving approval of resolution plan. Therefore, the IBVI may be think of issuing appropriate direction in this regard. So we have a three-way, we had offered in our paper a three-way solution for this issue. The first, we need to identify the waiver relevant for the operation of that particular CD. This can be done by the RP during the CRP, that introduction of a compliance audit in the line of the due diligence conducted in the M&A, where second, RP can vet all the contract entered by the CD so that he has the first-hand knowledge of the compliances need to be done under any other law, and thereon the said compliances need to be passed out to the resolution applicant. Second, there is a Form H under the CRP regulation. That Form H may be amended to provide the list of compliances and approval needed to applicant, and there should be a time limit provided under the code for each authority under any other law for granting this approval, and there is and we need to introduce a concept of deemed approval. Suppose that authority is not approving within timeline, then that should be need to be approved.
Mina, I think you need to conclude. Your time is up.
Just 1 minute. Okay, I will wrap it fast. We have just 2 more.
Just 1 minute to conclude.
Okay, so just to fast
Can
point.
you just finish in like two, 3 sentences?
Oh,
if possible.
okay, just two issues. We need one issue is to
Sure.
give in a time frame to A for approving the resolution plan because there is so much pendency on that part. And second, the last issue of our is there is a uniformity of judicial review in the code. Under the code, when the registration of any IPA or IU is not granted by IBBI, that can be challenged to NCLAT, but there is no such remedy available for IP. So just uniformity on this approach. Thank you.
Okay, thank you, Pooja. Yeah, so thank you. That was a very good presentation. I think you've dealt with this paper seems to deal with a lot of issues, each of which I think can be its own paper and very interesting suggestions. One question I wanted to ask, because I think your title is about fairness and equity. And to me, all of them, and I just wanted to understand how are you defining or looking at fairness and equity, because some of the suggestions didn't exactly go to me into fairness and equity. For example, you're talking about the collation of claims and saying the RP, the suggestion you had there was about the RP being empowered to decide on the claim similar to a liquidator. So I just wanted to understand how does that go into fairness specifically, or are you looking at fairness and equity much more broadly than what I was thinking?
So ma'am, it is with respect to the powers that have been granted to resolution professional versus liquidator, because we have the core objective of the code as reorganization of the corporate debtor and not the liquidation, because it is considered as the last resort. So I think in resolution, the power should be extensive and not in the liquidation. We can have the same powers in case of liquidation also, but we think it should be fair in case of resolution also.
So you're sort of comparing the powers of liquidator versus resolution.
Yes.
Yeah, these are very,
And I have a comment that you have selected too many topics and maybe you could not just make justice. At least some you could see outside what does ancestral says, what does other jurisdiction have on these parameters. Otherwise, it just becomes your opinion sometimes. So have some small issues, but go deep into that. Or if you can expand even this present paper with some insights from practices abroad, that will be great help.
Sure, sir. We'll take that into account while finalizing the paper. Sir, in the paper we have written many things. It's just because it's in the slides were limited, so we couldn't present here.
No, sorry, can I?
go ahead. Yes.
No, so I just two things. One, what Sumant mentioned, it's a smaller point, but very, very important point about this, which if IBBI can please take into account, because what it's doing is it's delaying the approval of the successful plan.
Yeah.
So, as they correctly say, if you have a grievance, please take it up sooner than later and certainly not wait till approval of the plan. So that's a very good point. And unfortunately for you, your second last slide, which is again something which is a huge point, it's not a small point, is implementation, Ritesh ji. There are cases, obviously I can't take names, but they have, a plan is approved, not implemented, so they are taking use of the assets of the company for 2 years without any payment. And we are talking thousands of crores, so the banks get no money, they get full benefit, and there's no implementation. And now that has become a nice model. So anyone who wants to do Hera Fairy says, let's follow this model. Free mein mil raha hai. So that second last slide was a very big one.
No, I thought that was very important also. Also that whole thing about approvals from different authorities, right? That's what that timeliness for that. So I think they're all very good recommendations. I do agree with Ritesh ji that, maybe you can focus on a few of these. I think one big one is this whole difference between liquidator and resolution professional, and there are lots of issues on that. And even just looking more deeply into that, looking at how it's done elsewhere, which I think you've done in your paper, could be a very effective paper. Yeah.
Not just a fair and equitable point, it also goes beyond this to seeing how it can reduce the workload of the NCLTs. Because today there is a lot of clogging of the matters because these claim issues go there because RP says I am only supposed to verify, I can't decide.
Yes.
So even small matters which hopefully the parties will accept his decision end up on the in the NCL.
So we have also proposed that there should be mandatory timelines for filing the appeal so that it doesn't delay the entire resolution process. We have suggested that.
Because Supreme Court has interpreted the powers of president or as a president, but if they qualify, then you can overcome that judgment.
Yes, sir. Actually, in SRSTL, Supreme Court has said that the power is not adjudicatory in nature. So, yes, sir.
This success fee, you proposing or opposing?
We are proposing
Opposing,
success.
You are proposing
For RP also.
for RP.
Actually, we are saying, sorry.
So, this fee structure is not there in the regulation. Do you support fee structure to be provided by IBBI? And if yes, in which format or structure, like it should be related to a performance, like you till the stage of this admission, you will get this much, so that he will act faster, or he knows this much is the fees only is coming this way. So by delaying that, he will not get anything, he will lose. So what type of structure you have any thought?
Actually, sir, in liquidation, we have linked the fee with the success of the liquidator. If he's allocating the asset in the first 6 months, he will getting higher fee. So we may contemplate some such type of framework in CRP also. Because in CRP, time is more essential than in liquidation. I'm not saying in liquidation it's not essential, but in CRP, time has a more value compared to liquidation, sir.
Okay, we'll talk. I had other things, but we'll stop here. No problem.
Thank you.
It was really
Just
very
to have a
interesting.
very
Thank you, ma'am.
quick comments. I think all points are absolutely good, but I think the point is that I would suggest that each area you can have one research. You can take a team, you can take a lead, and then do the research. I think that would be really fruitful.
We'll try to
And
go
then-
deep
and
into the
that's
major issues, sir.
And I think you have missed one point, that this law is a commercial law, not a socialistic law. So when you talk of equity and fairness, it should come from the commercial side. Like here equity comes from section 53 or the waterfall, no? Not from like providing jobs or like the PF and all that. That should be kept in mind. So fairness
Sure.
equity has a different angle here.
Okay,
Sure,
sir.
Thank you.
Thank you, ma'am. Thank you, sir.
The second presentation for this session deals with the topic Resolving Discoms under the IBC, a comparative law approach. It would be presented by Mr. Pratik Tata.
Good afternoon, everyone. Thanks to the organizers. I'm Ahmedabad and IBI for having us all here. This presentation looks into one specific sector, which is the electricity sector, and I'll point out to the recent developments that kind of motivated this discussion. So before I get into that motivation part, let me just give a broad overview that may be relevant for the purposes of this discussion. So discom stress is one of the biggest problems facing India. This is a matter that is usually discussed in a separate group. So we probably as insolvency lawyers and policy thinkers do not talk about this, but so that's why this one slide. So in the electricity sector, there are essentially three parts, right? Someone generates the electricity or produces the electricity. The electricity is then transmitted over high voltage wires. And finally, there's a step-down mechanism by way of which the high voltage is reduced to low voltage and transmitted to the end user, right? So there's the generation, there's the transmission, and there's the distribution. Now, when India got independence in 1947, after that, in 1948, we had our first Electricity Act. Obviously, pre-independence, there was another one in 1910, but the first Electricity Act was in 1948. Now, this Electricity Act brought both, all the three, generation, transmission, and distribution under the state electricity boards. So they were brought within the complete control of the state. Now this situation continued till early 90s. In October 1990, generation of electricity was liberalized, although transmission and distribution remained within state control. Now the situation as of today is that most discoms are basically the shortened version for electricity distribution companies. Most discoms are state-owned. 10% of distribution happens through private distribution licensees, whereas 47% of generation happens through private sector players, right? Now, discoms usually have monopolies in their area of functioning. This is a very unique attribute in this sector. And most of them, as I mentioned, are owned by the state, and therefore a lot of political economy pressures influence this sector, right? This is the reason being, as we know, increasing electricity rates will have huge political implications, and that's why this sector is riddled with a lot of political economy challenges. And this is the fundamental reason why you have stress in this sector, right? Now, according to some estimates, the total discom losses for FY 2021 was around 0.9 trillion rupees, which is around 0.7% of the Indian GDP as of 2021, right? And overdue payments to generators was 0.68 trillion, right? Because so that if the discoms are in stress, they are unable to pay to the generators who are producing the electricity, right? So it has a systemic issue also. So it is in this context that the question of what role can IBC play in resolution of this discom stress is something that we need to really ponder about. And the reason why we need to ponder about it at this point in time is because late last year, on November 8th, 2021, there were two developments that happened. First, the Madras High Court, in a judgment, gave the decision against the discom because it held that the IBC does not exempt any government company under Section 2, subsection 45 of Companies Act, including state-owned discom. Now, the position of law was pretty much clear. However, as far as the discoms are concerned, this was a clear judgment that clarified that, yeah, discoms are like any government company and therefore can be subjected to IBC proceedings. And the same day, the Union Power Ministry also clarified via letter after taking opinion from the Legal Affairs Department that discoms could be subjected to IBC. Now, this led to some thinking inside the government as well as outside about what will be the implication of putting discoms into IBC, right? I mean, will there be going concern sale? What happens if a discom gets liquidated, right? Who provides electricity? Suddenly your power goes off and then, you know, it's a complete mess. So this paper is based in that context. It tries to, you know, first inform the debate rather than coming up with any conclusive policy suggestions. So unlike most of the presentations that we have seen till now, I will be actually putting the questions to you rather than you putting the questions to me. Okay, sorry. So the methodology that I will follow is, I'll review the experience of insolvency resolution in the electricity sector in the US and the UK. I will highlight some of the idiosyncratic legal features that have arisen in these cases. And the aim, as I said, is to inform the discussion on discom resolution under IBC. Hopefully, this will trigger a policy discussion, and this paper is not going to make any conclusive policy suggestions. So USA, right? Okay, so the context in US, just a historical timeline. So during Great Depression, there were around 53 utility holding company bankruptcies in the US. Then they brought in an act, PURP Act, Public Utility Something Something Act of 1935, which substantially reduced the number of electricity holding companies. And after that, the energy demand increased during 1960s, so there were no further insolvencies after that. During 1970s, there was high inflation, high interest rate, and crude oil prices also went up, because of which electricity prices increased and consumption reduced. And just before that, there was a lot of, because energy demand was growing pretty healthily, a lot of investments went into nuclear power production in the US. Now, in the 1970s, because of all the other factors, when electricity demand started reducing, a lot of this nuclear power investors found themselves in trouble. So this was the first time, and as you know, the US bankruptcy court, new one came into effect in 1978. So the first test that happened of the code vis-a-vis the energy sector was vis-a-vis the nuclear power plants going kind of going into restructuring. And that's when this issue of how do you allocate costs between the consumers and the investors in the electricity sector became an issue in the restructuring, right? Nowadays, however, utility bankruptcies are quite common given the competition in generation and also climate change risks. Now, as far as the US law is concerned, there are very few special provisions specifically targeted at the electricity sector. So one, for example, is section 1129A6. This is basically the confirmation of the plan, the section which is like, in perimeteria with, say, section 31 of the IBC. This provision basically says that any rate change provided for in a plan must be confirmed by the relevant regulatory commission after confirmation of the plan, right? The reason why this provision exists in the 1978 Act is because under the FPA, the Federal Powers Act of 1920, the FERC had jurisdiction over this issue, and there has been a lot of clashes between the bankruptcy courts pre-1978 and the FERC. So that's the reason why in 1978 they clarified this provision in the law itself. For all other practical purposes, utility insolvencies are pretty much treated just like any other insolvencies. However, there are some idiosyncratic issues, as I mentioned, and one that I'll be focusing on, which I consider to be the most important for the purpose of this audience, is the rejection of executory contracts like PPAs through bankruptcy. Moving on, I'll just again, this is something that was discussed yesterday by my colleague from Cyril Lamachand, Mr. Bisht, who had discussed the executive contracts in great detail. So I wouldn't go into that much of detail. I'll just give you a broad overview. So under 365A of the US Bankruptcy Code, what it says is that except in certain cases, the bankruptcy trustee, which is the equivalent of an insolvency professional or a resolution professional, subject to the court's approval, may assume or reject any executory contract of the corporate debtor, right? Now, in the US, there has been a lot of debate about what's an executory contract, what kind of contracts can be rejected, et cetera, that debate is, we had a review of that debate yesterday. I'm not getting into that part here. So the main point that I'm making here is that under the US law, a corporate debtor, once it is inside the Chapter 11 proceeding, can reject any contract under which it has ongoing future obligations, right? Because it considers it to be very onerous. Now, those of you who are aware of the Bhushan Steel Plant's acquisition by Tata Steel, this is exactly what happened, and the NCLT allowed Tata Steel's resolution plan to terminate the PPA that Bhushan Steel had with Bhushan Energy, right? So it's a bit like that that happens in the American context. And this is exactly why distribution and generation companies in US have used 365A to terminate power purchase agreements when they are in a Chapter 11 proceeding. And that's one of the advantages that an energy company gets by triggering a Chapter 11. Now, what's the friction that is caused? The friction that is caused is that when you're terminating a power purchase agreement as a DISCOM, you are probably doing that because you can purchase energy for a lesser price from some other guy, right? That's the main reason. Now, the moment you do that, you are essentially changing the wholesale price of electricity without the FERC's approval, because FERC under the Act, okay, let me just move to the next slide. So, FERC gains its jurisdiction from the Federal Power Act of 1920, as I mentioned. The Federal Power Act's main purpose is to protect electricity consumers through orderly development of plentiful electricity supply at reasonable rates. More specifically, FERC has exclusive jurisdiction to determine the reasonableness of wholesale electricity rates. And therefore, every privately negotiated energy contract in the US must be filed with the FERC and certified as just and reasonable for it to be lawful under US laws. Now, this is called the filed rate doctrine. Essentially, it means that a utility's right to a reasonable rate under the FPA is the right to the rate which the FERC files or fixes, and these rates cannot be challenged before a court as unreasonable. So the question is, when no court can hear a challenge to these rates as unreasonable, how is it that the bankruptcy courts can come and nullify these contracts, right? So even the FERC actually cannot change these rates themselves. The only thing that it can do is it can change a file rate under certain circumstances. One is that if it may impair the financial ability of a public utility company to continue, or cast upon consumers an excessive burden, or is unduly discriminatory. So these are the three grounds on which FERC itself can change the rates. And therefore the question arises is that if neither the private parties nor the regulator can change the rate, who is the bankruptcy court to come and suddenly terminate the contract, right? So there are 4 cases that are important from this perspective that discuss this conflict. I won't discuss the first case because it's old and also it really does not squarely address the PPA issue. I'll be discussing the 3 other cases, the Mirant of 2004, Calpine 2006, and First Energy Solutions 2019. Hopefully this will give you some flavor of the actual disputes that kind of arise in this sector. Now, let's start with Mirant. Okay, so Mirant was a power producer and purchaser. It bought out the power generating facility from a public utility called PEPCO, plus the PPAs that PEPCO had with other producers, right? So other sellers of power in the wholesale market. However, some of PEPCO's contracts, some of those PPAs were non-assignable. So what PEPCO did was it entered into a contract with Mirant saying that, okay, I cannot assign you this PPAs. What I'm going to do is I'm going to buy this energy the way I used to do under the PPAs, and you enter under a contractual obligation that you are going to buy out this energy from me, right? So a new contract was entered into post this transaction. Now, what Mirant sought to do after a couple of years was to enter into Chapter 11 and nullify that contract, that obligation to purchase power from PEPCO under those non-assignable PPAs, right? And the court actually allowed this rejection. The reason was that the energy that Mirant was taking so long from PEPCO was no more necessary given Mirant's new business strategy. So that was the reason that we are changing our business strategy. We don't need this energy anymore, and therefore, allow us to terminate this contract. And the court allowed it. In Calpine Corporation 2006, this was a slightly different case where Calpine was a power generator. It entered into PPA to supply electricity. It took a huge amount of debt to build those power plants, but in the meantime, the natural gas prices went up, right? So the prices that were fixed under the PPAs were significantly lower. So it was in Calpine's interest to renegotiate the contracts and increase those prices. So what they did was to trigger a Chapter 11 in which the only reason that Calpine gave was that I'm happy to supply the electricity, but not at these prices, but at the market determined price. The court said no. What you could not have done without the consent of FERC, you cannot use the bankruptcy court to do the same thing, right? This is avoiding FERC. So the court refused granting this approval to terminate the PPA, right? So this was the exact opposite of what Mirant did. Now, then comes First Energy Solutions in 2019, and what happened in this case was that the DISCOM had 3 different businesses, which was to distribute to the retail, to some corporate affiliates, and to sell in the market, in the open market. Now, after some time, they decided to sell off the retail business. Now, the retail business in US at that time, when they were in the business, were required to purchase RECs, the Renewable Energy Credit, right? And because at that time, this was in 2003 to 2011, RECs were in extremely short supply, and therefore, FES, First Energy Solutions, entered into long-term PPAs to purchase RECs at a reasonable rate, right? Now, they purchased these RECs through PPAs because they were in the retail segment. Now, in 2011, the board took a decision that we don't want to be in the retail segment anymore, right? We want to sell off this business and get out. The question was, if you want to get out of this business, can you terminate these PPAs or not? And the court allowed this termination, saying that, they don't need it because they are getting out of the business. So it seems that the US allows termination of PPAs through bankruptcy court if it is a part of a genuine restructuring of the business, not when they are trying to avoid the FERC's jurisdiction through the bankruptcy courts, right? This is one of the main uses of bankruptcy code in the electricity sector in the US. Now, coming to the UK context, I have like 3 minutes, 2 minutes, okay. So I'll quickly wrap this up. So in UK, okay, we know this, Thatcher came, privatized everything, the electricity sector got privatized. So the Energy Act 2004 and 2011, there are two. They have actually a provision for failing energy supply companies. Ofgem, which is the energy regulator in UK, has three levels of strategies. So the first thing when an electricity company goes back, enters distress, is to try, where the regulator tries to get it into a private trade sale. If a private trade sale fails, then they try and revoke the company's license with 24 hours notice and appoint us SOLR, which is supplier of last resort. This is a bit like what happens in banking under the BR Act, where the company, a bank gets merged with a healthy bank under Section 45 of the BR Act. The third would be to revoke the company's license with 24-hour notice and apply to the court for a energy supply company administration order. This is a special regime that has been created under the Energy Act to deal with big energy companies. SOLR is for small companies. So under SOLR, the Ofgem asks its suppliers, competing suppliers to the failing business, if they are willing to be considered as a supplier of last resort, and what would be the terms of supply. And Ofgem also has the power to direct a supplier to act as SOLR. Once SOLR has been identified, Ofgem revokes the license of the failed company, and the supply is immediately placed with the new company, which is going to act as SOLR. The failed company is liquidated just like any other company under general insolvency law. The ESCA is slightly different because this is meant for, the blue moon, the like once in a blue moon kind of instances where big companies, like the first company that has gone under ESCA is Bulb. Last year, it went into ESCA. So the main differences are that here the duty is actually to balance the interests of the creditors as well as consumers, which is not a duty under general insolvency law. And the administrator is required to run the company till it is restructured, sold, or its customers are transferred to other suppliers. Some unique provisions in the ECA is that the Secretary of State may make grants or loans to the company into the administration. So it's like an interim finance being provided by the state, but there's a provision where it requires approval of the Treasury, which is the Finance Ministry, and the government funding is recovered through a levy on the industry. So these are some special provisions that's there in the, in the special administration for energy companies. So ESC, as I said, was untested till now. It's only in 2021 that Bulb Energy, with 1.7 million customers, has gone into ESC. We are yet to see what's the result of that. So applications for India, areas to look out for. These are the questions that I have for you. Can DISCOMs undergoing CIRP cancel burdensome PPAs through NCLT? The second would be, can tariffs be altered through IBC if low tariffs is the reason for DISCOM stress? And the third would be, will a SOLR or a special CIRP regime for DISCOMs work in India? Thank you, ladies and gentlemen.
Thank you. We'll have a few questions. No, this is very interesting. I'd like to wish I could push you and ask you if you had any thoughts on, especially the first question, I think is very interesting. I mean, I think the larger question is whether we need a special regime for DISCOMs. But on the first one, what is your view? Do you think that if this were done specifically, would this greatly help the DISCOM resolution process?
So I'll give you my narrow perspective. I'm still forming an opinion on the subject, so I don't want to jump into this because electricity is a very complicated sector and I don't understand it fully. I am looking at it from the perspective of the insolvency law lens, and from that narrow perspective, what seems to have happened is states like Punjab, Gujarat, Rajasthan, Karnataka, and UP have all tried to cancel PPAs because, as I said, the DISCOMs are owned by the state government, and the state government's incentive is to keep the prices low. Therefore, whenever they have any other alternative sources of cheaper energy, their incentive is to scrap all the earlier PPAs, right? So Andhra Pradesh passed an order sometime in 2019 doing the same, where they wanted to cancel the earlier PPAs, and the Andhra Pradesh High Court said that no, you cannot do that, right? Now there's a tension here. The governments want to move their sources to some cheaper source, but they can't, right? But there's a risk that sometimes they will act arbitrarily, they will not respect contracts. The question is, can we create a legal framework to handle this tension, right? Now, IBC provides that platform to do that. provided, I mean, there's a section 20 subsection 2 clause B, which empowers RPs to amend or modify contracts entered pre-CRP, right? Now, this is not yet tested in the context of PPAs, but I believe that if IBC could provide a platform for distressed discoms to come in and terminate PPAs, a lot of state governments would be interested in this. And because they are clearly interested in cancelling PPAs, but the way they are doing it seems completely arbitrary, right? They are just using their legislative power to arbitrarily scrap PPAs. So the question, from this perspective, it seems quite legitimate if IBC allows for a platform for state governments and their discoms to come and renegotiate their PPAs, right? But again, we have to think through, like the US courts have done, under what circumstances could those powers be utilized? They cannot be utilized in the whims and fancies of the government, but only when it's a part of a genuine restructuring of a discom.
I have a comment to make. Basically, in electricity, there are three kinds of players. One is the discom that you have covered, one is transmission, and one is generation. My worry is about this, the third aspect. Means transmission as such is doing good. Discoms are doing good, doing bad because of their own inefficiency or own compulsions. But the generation companies somehow are affected by the policies, especially the thermal power ones, or so. And those are the ones which are in the private sector. So it worries that if such things happen, they will further go down, and their risk will further go up, going to insolvency or something, which in a sense can affect the country.
I agree. So as you correctly point out, whatever happens in discom is going to directly affect the producers of power, who are just generators. The question is, would they be better off than today? Today, arbitrarily state governments are cancelling PPAs. No one, therefore, except for the biggest players, would be interested in this coming into this sector in the generation. Even if they come, they will charge very high discount rates because of the risks, the policy risks, the sovereign risks involved, right? So the question is, how do we reduce those rates, right? How do we reduce the risk? Can we provide a legal framework through which PPAs can be renegotiated? The question is, can IBC provide that legal framework? Now, all that I'm saying is that I agree with you, it's a complex sector, there could be a lot of other implications, but as of today, there is nothing. I mean, so Punjab comes up with a law saying that all our earlier PPAs are cancelled. This is completely arbitrary. No one's going to invest in Punjab generation if the Punjab government can overnight cancel all the earlier PPAs. The question is, given this context, can IBC stabilize the ecosystem by providing a platform, by providing a jurisprudential basis for cancelling PPAs through IBC when a discom is under stress? And I believe that IBC holds potential given what we have seen in the US markets. IBC could hold potential if we can think of something like a special CRP regime for electricity companies. But again, those are slightly different. That would require a more holistic coordination between IBBI and the Power Ministry probably, and CERC, etc.
My concern is that even if we give power to discoms to go through some process and terminate the PPAs, it makes the other parties least lesser interested. They would like to keep higher margins. So ultimately, it harms the sector. This sector is very complex.
No, it's a complicated sector. That's why I said it's a very complicated sector, and these are just initial thoughts. Yeah.
Basically, what I see the problem here is the defaulter is not the CD, but the government, to whom you cannot take to IBC. Here, state governments are the defaulter.
No. The state government owns the defaulting company. So the defaulters are the
discom. Is a
discom.
different entity. Government is a different entity.
Yeah, so the defaulter is the company, not the government.
No, state government is defaulting but not paying to this company for the supplies.
No, okay, so so there are other chains. I agree, yeah.
The problem
Yeah.
lies
Yeah.
where the state government is not paying on time, leading this company
Yeah.
to default.
Yeah.
So even in the current model of IBC, you can take this company to IBC?
Yes, you
No,
can. Yes.
Yes. So why not take them to IBC, and then there should be a provision to renegotiate the PPAs. So this power should not remain with the government.
No, it has to be through
should be
IBC.
with
No,
the
absolutely,
NCLT member,
absolutely.
that as per resolution plan, either they can forego with the PPAs or renegotiate. That should be
Absolutely.
the power given to the resolution applicant.
Absolutely.
Okay, so that solves your problem.
Exactly.
Yeah.
That's the point that we are making.
You
yeah.
see that Tata Power in Gujarat.
Right.
So ultimately they waited to renegotiate with the government. And here
Right.
the problem, if the government goes back on contract, that is a breakage of rule of law. See, government cannot break the contract. No? Anybody else can be a defaulter,
Right.
not the government.
Right.
So that will be a very bad precedent for the country, that
Absolutely.
government backing out on
Absolutely.
the contract. On the other hand, the defaulter company can always be taken to IBC and resolved. And in resolution plan, one of the thing is PPA renegotiation or maybe termination.
Absolutely. So that's completely agree with that.
I think let me add. Yes, Pranava. I think Pratik, I think you have made a really absolutely good point, and I'm really cognizant about these issues. And I propose that from IBBI we will take forward this issue through the forum of regulators, and we will have a discussion with the experts panel. So I will take that lead. Second issue is which you are mentioning about the inter-se jurisdiction between the other act and IBC. But our IBC is a little bit clear, because section 32 says RP resolution plan should be consistent with the other laws. So we, in our IBC, there is already a provision which the USA introduced later on, but we have. So I think that takes a little bit care. But as far as this insolvency of the DISCOMs is concerned, what will happen? There is other provisions of the act says that once the utility is getting insolvent, but at the same time that license will also get cancelled. Because what will happen if he's defaulter in their utilities, then the license also they will default. And once the license is default, then automatically their rights of distributions will get revoked.
Right.
So what will happen? There could be two parallel process. And now if the resolution plan is getting submitting, then they have to. Another issue is that the resolution plan, who is the incumbent is there, he has to qualify those criteria. So RP should have to submit that. And there is a provision also that in our section 20 and 20 and 24 of the Electricity Act 2003, it provides the sale of utility. So our jurisdictions provide that how to sell of the utilities and sell of the transfers. So that takes care of this little bit. But what you are suggesting here is no solutions. I think here are all questions. So look into those provisions and make some suggestions and some propositions. I have also some propositions in my mind.
Sure.
Also we can deliberate on this issue.
Sure. Thank you for that, sir.
So just one last very small short point. So, so with regard to the recommendations made, I have a slightly differing opinion wherein if you read that Honorable Supreme Court's order of Gujarat Urja Vikas Limited, it has the NCLTs they're supposed to be very reticent when they are exercising their jurisdiction under clause section 60 subclause 5, which is like the fountainhead of all the litigations and all the powers that the NCLT has. So when we are actually requesting the NCLT to sort of surpass the competent authority and assume power of other authorities to resolve a DISCOM, I think generally everybody would be a little reticent when it comes to the Indian jurisdiction. Like
No, that's a fair point. Fair point. I mean, that's why these are not recommendations. These are all questions. This is meant to inform the debate. That's all. Yeah. Thank you.
Thank you, sir.
Thank you.
This is a very interesting topic. Sorry, we didn't have enough time to actually go.
We are constrained for time, so I request the questioners to stick to a 5-minute time limit. The third presentation for today's session deals with the topic situating mediation within India's insolvency framework, an innovative and efficient intervention. The presenter is Ms. Akriti Tiwari.
Good afternoon, everyone. I'm Akriti. I'm a third-year BA LLB law student at Jindal Global Law School. So as mentioned, my topic is situating mediation within India's insolvency framework, an innovative and efficient intervention. Sorry, how do I? Okay, thank you. Right. So essentially, the introduction and objective of this research is largely because, as we've seen over the last 2 days as well, there is a pressing need for certain reforms to be enacted in the IBC. Right, we're looking at a lot of time delays, and as I remember in yesterday's session, Mr. Shardul Shroff in fact mentioned about how natural justice tends to actually be detrimental at times when used with the IBC, right? It can cause several delays. There are several technicalities that actually waste time, right, with respect to the adversarial process. And so for that, the response that I wanted to formulate is something that's been a burgeoning topic among researchers in India, and that is introducing mediation to combat the same. So the existing issues in the enforcement of the IBC, of course, are through court delays. There's too little infrastructure to deal with the high number of insolvency cases, and that is why, of course, the suggestion is made. Right, so the aim of the research is, of course, to situate mediation within India's insolvency framework by borrowing from other jurisdictions as well. India, very uniquely, also has a lot of roadblocks that I intend to maneuver around. And I believe that that is a sort of a newer intervention in this topic, because generally we stop at, it works in other jurisdictions and hence it'll work in India. Right, so of course, principal methodology is I relied on qualitative content analysis, which is secondary resources. Being an undergraduate student, I had to speak to some practitioners, so interviews, of course, the judgments of courts. So that has been essentially my approach. Now, I started with a cost-benefit analysis of mediation in Indian insolvency. And to begin with, the relevance is largely exacerbated by the COVID-19 pandemic, because what we're really seeing is a blurring of borders and a complexity in the nuances of insolvency disputes. That complexity that I will argue throughout my presentation is what prompts us to actually expedite the process towards moving towards alternatives. Right, so mediation, I'm going to talk about first why mediation by talking a little bit about the process. So mediation can be understood to be a facilitated negotiation, right? There are four tenets of mediation. Of course, firstly, it's a confidential process, right? Secondly, it's a voluntary process. The parties volunteer typically to associate themselves with the process of mediation. They may choose not to engage anymore with mediation if it's not working out and they're not able to reach a settlement. The mediator must be neutral and impartial. He cannot be connected with the dispute, and hence facilitating that dispute is generally through a very fair means of mediation. Additionally, it's a process of self-determination. So the parties come to a settlement, and it's not coaxed by the mediator in any way. We do have statutory basis for mediation in a domestic and international context. As I'll elaborate, in India we have seen several legislations such as for MSMEs and RERA and many other statutes that have actually taken cognizance of mediation and done fairly well with them. In an international context, we can look at Article 4, for example, of the Hague Convention for the Peaceful Settlements of Disputes, which enshrines the aforementioned principles that I mentioned into law. So it touches on the mediator's role as a facilitator and bringing parties with opposing views to a settlement. Under Article 4, mediators diminish hostilities to ensure a negotiation is productive. Right? Now, mediation is not formal. There's an attitude of win-win versus win-lose. The most important word in a mediation is generally stakeholders. And that's a word that, not coincidentally, we've seen being brought up multiple times over the last 2 days. Because insolvency, a good insolvency regime, at the end of the day, like I think some of my co-presenters also mentioned, is one that will keep in mind stakeholders and their interests. Mediation structurally is exactly that. Whereas in an adversarial process, we're still looking at a win-lose. So if we are able to measure out stakeholders and equate their interests, that's sort of not exactly a commonality, I would say. So benefit of all stakeholders, of course, well suited to insolvency. Insolvency processes are stakeholder driven, and they're entirely based on mutual benefit of all parties, right? We reach a creative, mutually beneficial solution that is party driven. It's reflective of logic, interest in the best solution, rather than application of law to facts. And this kind of brings us back to, again, natural law being a bit of a hindrance when it comes to perhaps arguments and going over in good technicalities in court that only delay the process. Again, win-win versus win-lose is where we really want to be. Now, mediation is less clinical, and both parties do stand to gain. The IBC's unique ability is that it tends to balance the benefits and gains of all stakeholders, creditors and debtors. And this is why it's such a landmark legislation, as we've seen. And the success of the insolvency system, again, is of course in how you balance the interests of these stakeholders, which makes mediation most suited. Now, in a court or an arbitral tribunal, one party loses, another gains. This has its merits, and it's definitely premised in firm notions of justice and equality. However, business disputes often require that all stakeholders' interests be balanced, along with their obligations and assets in a fair and equitable manner. Because of adversarial systems, this has not necessarily been the case in practice in insolvency law. Now, the NCLT is the appropriate forum for all matters currently pertaining to corporate insolvency. Jurisdiction of any other forum is ousted, as per, of course, the judgment in Dhulabai versus State of Madhya Pradesh, which places, of course, an express or implied bar upon the same. And this greatly increases the burden on an already overburdened system to hear, decide, and dispose of matters within record time. 270 days ensures that goal of time-bound resolution entirely bypassed. Even extending it, as in the case of SR Steel, to 330 days does not seem to have made much of a difference. And of course, time-bound resolution being an integral part of the code makes a slightly troubling predicament we find ourselves in. And we've seen that litigating insolvency disputes is one of the most time-consuming aspects of the process, right? So provisos to section 12(3) of the IBC extended the 270-day limit to 330 days, an equally unfeasible limit as stated. Concerns materialized, for example, in SR Steel versus SK Gupta, and the court, essentially said that proposing a mandatory sealing could contravene fundamental rights through Article 19(1) of the Constitution. So the term mandatorily, essentially, when we look at mandatory mediation, we look at mandatory adjudication. While, of course, we do understand that the implications for this may come off as contradictory, what we're really trying to do is to get parties to essentially flesh out and resolve their disputes at its core. We're not necessarily losing ourselves in the technicalities of the matter anymore. And then, and yes, so I'll just move my screen. Right. So now, when we move to looking at mediation in an insolvency in an international framework, what we really are trying to do is look at how it's been a wild success in other jurisdictions and why that may or may not be replicated here. I'll argue that the models, though being different, rather than being different models, they essentially have the merits and they keep those the same. So in the application of mediation in insolvency in an international context, we've seen a growing interest as a mainstream means of dispute resolution, right? So we've looked at, in the case of MSMEs, there's been a routine simplification of the process, especially post-COVID. When we look at Australia, the UK, and the US, and World Bank and UNCITRAL as well, have tried extremely hard to essentially bridge the gap between mediation and insolvency, right? So while mediation, of course, hasn't been explored as a means to resolve disputes in India, it has been, insolvency disputes in India, it's been extensively utilized in a foreign context. So nations such as the US, France, Singapore, Italy, and others have made mediation an integral part of how their insolvency frameworks operate. That being said, there has been a clear shift internationally towards insolvency as stated in a post-COVID world. Now, in an attempt to streamline the insolvency process, a great deal of deliberation has been made on moving towards a less formal and simplified resolution for insolvent MSMEs on an international forum. And this evolution has prompted foreign interest in mediation and insolvency. And the Singapore Convention Week, in fact, of 2020, held a panel discussion specifically on the use of mediation and insolvency. In Singapore, Australia, the UK, and the US, of course, we've seen the desire for simplification here as well. In 2021, in the recommendation B4 of the World Bank's Principle for Effective Insolvency and Creditor-Debtor Regimes have yielded strong support to mediation as a solution for insolvency processes globally. Additionally, the UNCITRAL legislative recommendation on the insolvency of micro and small enterprises have officially recognized mediation to ensure greater accessibility to insolvency regimes. Moving on as well, the UNCITRAL model law on cross-border insolvency, Article 27A, mandates the use of mediation for insolvency disputes. Again, the UN Convention on International Settlement Agreements resulting from mediation, or the Singapore Convention, has laid out framework for enforcement of mediation settlement across borders. What this means is that the international arena has fully taken cognizance of the merits of mediation, and more specifically the merits of mediation in insolvency disputes. And it appears clearly from looking at the case studies that we will be examining in the EU and the US, that it's been clearly a success and something that perhaps we could be inspired from to solve our own predicaments. So, for example, in the EU, which is our first case study, now we observe mediation in insolvency disputes in Germany, France, Italy, to name a few. And there's no formalized codified system of mediation within the insolvency process in the EU, but it's gradually adopted mediation through jurisprudence and case law. And the EU's primary objective is to rescue the corporate debtor. It's a debtor in possession model, of course. And the insolvency plan in Germany, for example, allows for debtors and creditors to arrive at a settlement via facilitated negotiation. Right. Moving on to France, two procedures allow for the mediation of insolvency disputes: the ad hoc mandate and conciliation. However, the Italian model is perhaps the most detailed and inclusive towards mediation in insolvency. Now, 3 procedures exist in Italy to resolve insolvency disputes through mediation. Firstly is a recovery plan. And the informal proceeds are commenced by the debtor. The debtor submits a plan, which is sort of certified by a qualified professional. And then for debt recovery, and then of course balancing stakeholders, they are able to negotiate that with the creditors, and if the creditors accept, then that is exactly what happens, right? It's an entirely confidential process, but it is a process that is underway in Italy right now. Now, only the assent of creditors is required on whom it is binding, and the courts are not required in any form. Now, a hybrid model, of course, is also there in Italy, where mediation takes place, binding on creditors, of course, participating in the negotiation, and the court takes a merely supervisory role to ensure that everything is legal and due process is complied with. Lastly, there's a preventive arrangement with creditors that is certified by a professional, which can be arrived at, which is largely a court-monitored process. So the negotiation itself will be facilitated by a judge as well as a judicial commissioner. So we see a lot of variation in even the basic interpretation of mediation as a process, which gives us a lot of flexibility with which to operate. Now, having a look at the United States, which is perhaps the best way of assessing how mediation has absolutely been a success, which is the US method of insolvency, which is the Chapter 11 insolvency, is a debtor in possession model. It greatly depends on the process of mediation to resolve insolvency disputes. So since 1986, the Bankruptcy Court of Southern District of California has established a mediation program. It's seen cases where we've had thousands and thousands of creditors having their disputes resolved through mediation in a very, very satisfactory and an expedited process. So these issues have clearly been able to be worked through at a lightning process compared to what would otherwise take years and years and years in court and perhaps not be beneficial to everyone involved. Now, through mediation, we've also seen the Lehman Brothers insolvency being handled, wherein we had multiple jurisdictions. There were very, very conflicting judgments in courts to the point where a proper solution was unable to be arrived at. Through mediation, I think around 77 of the disputes were mediated, which is almost all of them, and they reached a satisfactory conclusion in record time. Now, this is unimaginable in a courtroom in such a fractional amount of time. Coming to India, just to briefly go over a few of the roadblocks that I see. Now, we've seen in numerous cases that insolvency disputes are disputes in rem. This represents perhaps the most significant roadblock to mediation being accepted as an insolvency resolution mechanism, because a dispute in rem cannot be taken to ADR in any way or form. And that is a roadblock that, frankly, to bypass will be a perhaps difficult endeavor, but an endeavor that I think is certainly worth looking at and deliberating upon. Now, we have Vidyadrolya, Pioneer Infrastructure, Haryana Telecom that tell us that this cannot be done. And then, of course, then we have the mediation bill, however, is a hope for a consolidated legislation in India on mediation. And of course, this is very, very seminal and important. But at the same time, Schedule 2 of the mediation bill shows a lot of focus on certain disputes being barred, like family, industrial mechanisms. And that, at this stage, appears to be something that may be a bit of a challenge in terms of the scope of how we view mediation, because if disputes are constrained from being mediated, such as family disputes, then perhaps our conception of it is not as accurate or quite where we want it to be just yet. Right. So, and of course, so essentially, yes. Now, the proposal, just to quickly wrap up, because I think my time is running out, it's proposed that multi-party mediation be included within Section 12A of the IBC and Regulation 30A of the BBI, which deal with withdrawal of application. Now, while I think this is the first step, and not necessarily a complete discussion of how I think step-by-step mediation should be incorporated, I definitely think it's something worth looking into, because it's an ideal procedural time to mandate negotiation or mediation as parties are willing to reach a settlement to withdraw application. Why we have to tiptoe around this is because India is a creditor-driven system. It is not a debtor-in-possession model. That means that the two systems, whether we compare the US or the EU to India, are not analogous to each other. So we can't draw that comparison so easily. There has to be much more deliberation that goes into it. So, of course, they're in the space where we want to withdraw the application and a settlement has to be reached. I think I would argue that that's the prime time for parties to actually to work on emboldening themselves to reaching a settlement. Secondly, the balance of power between the COC and the promoters or directors would make it ideal for parties to enter into mediation, because at this stage, of course, while the process is creditor-driven as it is, with the COC having to approve the plan, it's also a time when the parties have to still reach a settlement that largely works for them. For a solution to be actually addressed to the COC, it of course has to be something that is feasible and that can be done. And therefore, I think that this would perhaps mandate a fair amount of thought into being a good point in which mediation could be inserted. Recent judgments show possibility of courts to overrule the wisdom of the COC as supreme, such as in Shiva Industries. Of course, while the COC is very much still held supreme and their wisdom is of course held above all. That being said, judgments such as Shiva Industries show us that the courts can actually look beyond that and perhaps think a little outside the box. And it's this outside the box thinking that we really want to use to inculcate mediation within the Indian regime. And the ability of the application to be withdrawn both before and after constitution of the COC lends flexibility to bring mediating parties to a settlement, especially if the COC has not yet been formed. Because right now, of course, the committee of creditors does not exist. There's less formalization in that sense. And so it might be an opportune time to introduce mediation in that context. Just to quickly conclude, this paper has strongly argued for the inclusion of mediation within the Indian insolvency framework. Of course, while this is outside the scope of the paper and I don't have enough time to delve into this, it also gives us a lot of opportunity for reflection on whether the creditor-controlled model is truly where we want to be in terms of envisioning the Indian insolvency regime. Right? And of course, mediation's relevance has grown by leaps and bounds because geographical borders are blurring. And as I've pointed out through numerous examples and legislations, the international arena has already taken cognizance of this. And I believe that it's time that we do as well. This produces several opportunities for critique and reform of the current code. And of course, our insolvency process might have an opportunity to grow even further than it already has. Thank you. I think that's it.
Yeah, basically you mentioned that confidentiality is an essential feature of this mediation.
Yeah.
But how does that work in insolvency? First of all, it goes to educating authority and then
Yeah.
it starts. So once it reaches the NCLT, it cannot remain confidential as such. And second point is, how does it help if I have defaulted on 10 creditors and I am having mediation with 10 creditors?
Okay.
It has to be a combined or a non-confidential process.
Right. I think, yeah, I mean, with respect to confidentiality, again, I think largely the process in itself is confidential. So I think what we're dealing with largely is the deliberations between the parties being confidential. Because even with the Lehman Brothers and other such examples, of course, it's a confidential process. We don't know what transpires on the table, but of course, we know that it happened. So I think that that would be how I would approach the whole confidentiality aspect of it. Whereas with respect to the second part, we've actually seen that with multiple creditors abroad, there have been areas where we've been able to reach very successful solutions. So I think if we were to actually, maybe the IBBI and a lot of different governing bodies could understand, how we could include that and maybe perhaps give some, recommendations to that effect, I think for sure we could see a lot of progress made, even if it's multi-party mediation, even if it's, I mean, in the case of Thompson Greyhound Lines, we saw thousands of creditors very, very successfully reach mediated settlement. So I think that there should be scope there. Yeah.
So I think everyone's quite clear that mediation would be very useful to have in the insolvency process. I think what would be helpful in terms of your paper is when you're analyzing these other jurisdictions, how did they deal with multi-party mediation and whether how much of it was actually incorporated into the law? Because I am also wondering about that, because I think the point of mediation is that it should be quite a flexible process and it should probably be permitted at different stages of insolvency. Both, of course, pre-IBC, that's completely up to the parties, but also post-IBC at different admission at different stages.
Right,
so I think it'll be interesting, to add quite a bit to your paper if you did a little bit of analysis on specific case studies in other jurisdictions and how much the mediation is actually incorporated into the law in terms of the process versus being more flexible about it and market-driven.
I think I'll definitely look into that. I think to that effect also, when reading about the EU, for example, we notice it's not codified in law. And it's just a precedent and perhaps it's almost like a legal tradition of sorts that's passed down. And hence that's how the framework has developed. I'll definitely look into it and I'll include it for sure. Thank you very much. Okay.
During the mediation, the law is that parties are not bound by what they say
in the mediation.
or what is recorded during the mediation.
Yeah.
So if supposingly I admit a debt of 20 lakhs there,
Yeah.
but I'm disputing the other debt, then the other party can't, and if the mediation is unsuccessful, the other party can't go to the court and say, look, 20 lakh was
Yeah.
admitted during the
Yeah.
mediation.
Yeah.
And therefore, I think to that extent, you read confidentiality from that point of view. Not that
Yeah.
confidential means the other can't see, but the fact is that those proceedings cannot be used against you in the event the
Right.
mediation doesn't work out.
Right.
And there is a judgment of NCLET also recently on
Okay,
that. I think you should focus on that aspect as well, because that would be the tricky part. Because we are
Right.
if you are incorporating it as a part or a process which is sanctioned by law,
Yeah.
then can you wriggle out of it by saying, look, I
Right.
said this during the proceedings, but I'm backing out by that.
Yeah.
And so that's the point also which was being made here
Yeah,
by
yeah.
your panel.
Right. Understood. I'll definitely look into that. So.
This mediation, we understand that it is to resolve a dispute
Yeah.
between two parties or maybe 3 or 4 parties.
Yeah.
So here the already default has happened. So you propose mediation at the stage of resolution of the
Yeah.
resolution
Yeah.
process.
Yes. Yes.
At that stage.
Yeah.
So
would,
at that stage, do you see any involvement of resolution applicant, because he is not there in the picture?
Yeah.
So only the stakeholders other than resolution
Yeah.
applicant.
The creditors.
So
yeah.
how much time you see that it will take that mediation? And they will do some like जैसे बोलते हैं आपस में बांटने वाला.
Yeah. Yeah.
That is what you are proposing?
No, I don't think.
मतलब जो है बांट लो आपस में. This is what we are proposing by
I
way
think,
of
yeah.
mediation?
I think no. I think that would be a very, very rational concern in a negotiation. In a mediation, I think I would want to believe that if it's facilitated, it would be a more organized process in that sense. And in terms of stakeholders, I actually think at that point it would mainly be between the several creditors and the debtors. It would not probably go beyond that in that case to introduce more stakeholders. But yeah, I'll definitely.
Will it not be a good idea to have a pre-mediation requirement before filing Section 7 application?
I
So
think
at least
definitely would.
there should not be a need for this filing this Section 7.
For sure.
A
Yeah.
mandatory condition. Right?
Yeah. Mediation. Right, right. Yeah. 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 Mediation. Mm-hmm. Yeah, yeah. Yeah, yeah. Yeah. Yeah, I think that would actually be the best alternative if we had to have an option, but yeah. Yeah, yeah, true.
Basically, what I see from presentation is there are two levels of mediation here.
Yeah.
One is pre-admission, one
Yeah,
is
and one is
post-admission.
post, yeah.
So pre-admission, of course, will happen between the applicant,
Yeah.
resolution applicant,
Yeah.
and the party, like
Yeah, if it,
defaulter
yeah,
party.
no, yes.
Okay, that can be kept confidential.
Right.
And as Mr. Batra said,
Post
is
filter, yeah.
the settlement here, should it be filed before the court or not? That is a moot question of law.
Yeah, yeah.
Because,
yeah.
see, in a default situation, there is always a continuous tension
Yeah.
between the creditor and a debtor.
Right.
What the creditor wants is an immediate payment,
Right.
like
right.
bank.
Yeah,
Okay.
yeah, yeah.
And what debtor wants?
Okay.
He wants a delay in the payment.
Right,
That is the
right.
continuous tension.
Yeah.
So the mediation or a settlement happens when these two comes together. So
right.
he gives a timeline.
Time,
Okay,
yeah.
I'll pay you, say, not today, maybe in 12 months. Some
Yeah.
agreement is reached.
Yeah.
Unless you give this agreement, file it in the court,
Right.
except as per a mediation, we have reached this conclusion.
Right.
So now this is filed, I withdraw my application. Because tomorrow this gentleman backs out of this agreement, then I
Yeah.
have a right
You
to
have a right to
restart my
enforce it. Yeah.
initiation
Yeah.
application.
Yeah.
That should be there, that will add value here.
Yeah.
And as regard the post-admission,
Yeah.
so now this comes to COC, because under section 12,
Yeah.
COC has to decide. So automatically there is a kind of process where there, in the CD or
Yeah.
the promoter sits with the COC,
Right.
because he has to gather 90% of the votes
Votes
here.
of the COC.
So unless 90% agree, that cannot
You
happen.
can't have,
So that is already given in the law. So we cannot add anything to that.
Right.
Thank you.
I'll definitely read into that. Thank you.
We have the last presentation for this session. The topic is From Lubrisol to Qimonda, Treatment of IP Licenses in American, Indian and Cross-Border Insolvency Regimes. The presenters would be Mr. Aditya Gupta and Professor M.P. Ram Mohan.
Okay, so good afternoon, everybody. Greetings to everybody on the panel, and a very good afternoon to everybody in the audience. Thank you for coalescing in this very hot afternoon and making our paper discussions worthwhile. Professor Mohan is busy with the conference, so I'll be taking the lead on the paper. The paper that we're presenting today studies the relevance and treatment of intellectual property licenses within a cross-border insolvency context. Now, the canonical text and the so-called template for adoption of cross-border insolvency regulations has come out to be the UNCITRAL model on cross-border insolvency. And through Article 8, this particular text clearly states that in interpreting this law, regard is to be had to its international origin and the need to promote uniformity across jurisdictions. Now, this particular paper attempts to study and import guidelines which have developed in different jurisdictions and then import it within the Indian insolvency context. This should go ahead, yes. Okay. So coming to the Indian law on the subject, while the IBC has been heralded as one of the most progressive financial reforms this country has ever seen, it does not regulate cross-border insolvency. The Bankruptcy Law Reforms Committee, which drafted the code, explicitly noted that our recommendations are limited to bankruptcy being a purely domestic issue. So, when this recommendation was put forth the Joint Parliamentary Committee, they disagreed, and hence 234 and 235 found their way into the code. 234 allows the central government to get into bilateral agreements, and 235 allows an insolvency professional to approach the NCLT and seek assistance in case assets and evidence are located outside the country, in a foreign jurisdiction, so to say. Now, the reliance on bilateral agreements to regulate cross-border insolvency is objectively problematic. Primarily, negotiating these agreements is a very time-consuming process. Every country will want its set of provisions, and we will end up fragmenting the cross-border insolvency regime, so to say. And even if it's not, like, since 2016, ever since we brought the code into existence, no bilateral agreements have been entered into. And while this is more of a theoretical argument, but even the practical side of it, we've seen in the Jet Airways case, the NCLT went ahead and said that the Dutch proceedings are a nullity in the eyes of the law, although the NCLAT then entered into cross-border insolvency protocol. But still, these protocols and all of this judicial guidance without statutory direction is a very problematic precedent to deal with. Now, IP licenses intellectual property licenses pose a very unique problem when in cases of domestic and cross-border insolvency, singularly because of the nature of intellectual property. The best example of this intersection is the American bankruptcy regime. Mr. Datta took us through Section 365, but I'm coming in from a different angle, so please bear with me. Now, Section 365 is the primary node of intersection when we talk about treatment of intellectual property licenses and bankruptcy regimes. The provision allows a bankruptcy debtor to reject contracts and agreements which posit a net obligation to the estate. Now, what does rejection mean? It does not assume a contract law analog. It has not been defined in the American Bankruptcy Code. The American bankruptcy courts have been dealing with it for a very long time. Specifically in the context of intellectual property licenses, in 1985, an American appellate court confused the term rejection with rescission and eventually ended up telling everybody that as soon as your IP license is rejected, your right to use the licensed intellectual property is extinguished there and then. So they've created a very problematic interpretation of rejection. So much so that in 1988, the American Congress had to step in. They brought in IPBPA, the Intellectual Property Bankruptcy Protection Act, and said that we will denude this judgment of its precedential authority. They introduced Section 365N, and Section 365N provides the licensees with a veto option, wherein he can say, no, I'm going to retain my rights. So that's how the IPBPA came into picture. Moving ahead. So let's come back to cross-border insolvency. How has it been incorporated within the American Bankruptcy Code? So they adopted Chapter 15 in 2005. The important provisions that I'm going to discuss today are 1506, 1515, 1521, and 1522. 1506, public policy exception. If anything is contrary to your public policy, don't pass that order in favor. 1515, a foreign insolvency professional can come to an American bankruptcy court, ask for relief. 1521 is discretionary relief. These are reliefs that can be granted on discretion of the American bankruptcy court. And 1522 is kind of a balancing approach wherein if the interests of your creditors are being hampered, don't grant the relief. As simple as that. Moving ahead. So this is the, okay. Yeah. So this case is the primary reason we started this research. There are a lot of judgments here. The only two that we're concerned with today are the November judgment and the November 2009 judgment and the September 2013 judgment. Now what happened here was, Qimonda is a semiconductor manufacturer, and this industry works in a patent thicket. There are millions of patents here, all of which are cross-licensed, and as soon as nobody knows whose patents are they infringing, so most of the patents are cross-licensed. Qimonda files for bankruptcy in Germany, comes to the American bankruptcy court, says that recognize our proceedings, and says that let us administer the 4,000 American patents that have been registered. The court says that's not how it's going to work. The German law does not provide a protection as concomitant to 365N. So you subject your law to 365N, only then will we give you the administration rights. So this was kind of the primary issue before the court. Okay, we have to go back. Yeah. So the primary, why this judgment assumes important in a cross-border insolvency context is because they interpreted Article 21, 22 and Article 6. How they interpreted 21 was, 21 inherently calls for a balancing test. Obviously, the interests of the creditors and debtors are going to be antithetical. Keep them that way. That's what the court said. You will have to balance these interests, then come to a decision. 1506, this was a bankruptcy court interpretation. They said that IP-BPA constitutes fundamental United States public policy. Their fundamental policy of quote-unquote promoting technological innovation, whatever that's supposed to mean. So both of these decisions tell us one thing, that as far as domestic insolvency courts are concerned, they will interpret these provisions in line with their doctrinal interpretations, expectations. And if that happens, we are fragmenting our cross-border insolvency regime. The point of moving towards modified universalism is kind of defeated. Moving ahead. Now, in 2018, our Insolvency Law Committee has given us a very beautiful draft wherein they've incorporated the model law, how their interpretation of it, how it should work in our country. Now, we suggest that the interpretation of this law, as has been applied in other jurisdictions, will affect our interpretation as well. Now, while this may be a hypothesis, but even the Insolvency Law Committee has cited the Qimonda dispute twice, both the bankruptcy court opinion and the Court of Appeals decision, in interpreting the public policy exception. Why have they not cited it in relevance of 21 and 22? We are not quite sure of that. Moving ahead. So this is what we are trying to study throughout the research. What happens when American bankruptcy court interacted with German insolvency law? We know what happened in Qimonda. What happens if American insolvency law interacts with our IBC in the context of intellectual property licenses? Now, we went through the code and the regulation attested with it. And we have divided this into two, liquidation and CIRP. Starting off with CIRP, avoidance transactions, as was also discussed in the panel, this is an area which does not have a lot of judicial interpretation or academic commentary, but still, there can be situations where avoidance transactions might intercept IP licenses, but that's not what they're for. Avoidance transactions try to intercept fraudulent and wrongful trading. So some licenses may be captured in that realm, but largely that's not going to be the issue, because these provisions are not catered to recalibrate business decisions. Apart from avoidance powers, there are residuary powers. Now, this is where I disagree with Mr. Datta, who's again not here. But Section 22B read with 23.2 allows an RP or an IRP, interim resolution professional or a resolution professional, to amend or modify contracts. Now, the NCLT Hyderabad and NCLT Mumbai has interpreted these provisions, and they've said that you cannot exercise these unilaterally. You have to consult with the creditor, only then can you exercise these. So if that is the interpretation, during CIRP, we can't interfere with pre-petition contracts. Good enough. We move on to liquidation. Liquidation has disclaimer. Disclaimer allows you to reject onerous property, reject performance of onerous property. Onerous property's definition includes unprofitable contracts. Good. But again, lack of any interpretive guidance, no case laws, no substantive case laws dealing with this. So we had to move to the UK jurisdiction from where we've adopted the idea of disclaimer, the provision of disclaimer. So in the case of Hindcastle versus Barbara, the court has explicitly said that disclaimers should affect the rights of third parties as little as possible, and the only point of including them within the statute is to freed the corporate debtor from their set of liabilities. This is the structure of IBC in reference to interfering with pre-petition contracts. Now, while we have conducted this analysis, even we admit that as far as our conclusions are concerned, they're relatively fragile, because all of our conclusions they're largely speculation that this is probably how they're interpreted. If that is the case, like for example, what will happen if a IP licensing agreement includes an exclusivity covenant? If you have an exclusivity covenant in your IP license, that will be an imposing obligation even after disclaimer. So will that exclusivity requirement be extinguished by a disclaimer? We don't know. So we're suggesting that before we interact with a different insolvency regime and fall into a kimonda of our own, form an administrative inquiry, study this issue, and at the same time, like what Mr. Bisht presented yesterday in Seminar Hall 2, I suppose, even he was saying that when it comes to pre-petition agreements, we have to look into whether or not it is necessary that we regulate them. So while you're doing this inquiry, maybe also look into that. Also, even the UNCITRAL has time and again said that we want to study this issue. In July 2013, they came out with a report. In July 2015, they came out with a report again. But they've never put the proverbial pen to paper. So we say that with these three issues, with these three conclusions, you can probably be prepared for a dispute like this. Now, I've wrapped up the presentation early because I know we're over time. So if I have any questions, please.
Yeah, so, no, thank you. And I think this is very interesting because I think there's been very little work done in this area generally, right? So just one small point before I ask a larger question. So when you're talking about the Section 22, you're right that the RP cannot unilaterally amend the pre-petition contracts, but they can with the consent of the COC.
Ma'am, the NCLT Mumbai decision 2018, DGM versus Geotechnics, I will mail it to you obviously. In there, the Mumbai court has said, even with the consent of COC, you cannot unilaterally do this. You have to bring in the creditors.
The credit, you mean the other opposite parties?
Yeah, the opposite party.
Okay.
Because if that starts to happen.
Yeah, because you can't, I mean, otherwise you can run. So, I mean, I think couple of things. One is, first of all, I guess there's not much clarity on dealing with pre-petition contracts under the IBC generally, right? Even in the domestic context, even before going to the cross-border context, I think, and I think IP licenses itself, presents its own set of issues. So given that, I would think you'd first have to look into those questions. Maybe the way it's dealt with elsewhere can inform that.
So, ma'am, we studied this. We have published on this. We studied US and UK.
Yeah.
But the problem continues. We're following the UK model. And when it comes to disclaimer, there is no litigation there. How do we interpret it? And even if we don't want to engage with, or even if we don't want to interfere with pre-petition contracts, there is a lot of literature, there is a lot of international guidance on why is it necessary. So whatever academicians suggest, there needs to be some kind of administrative inquiry into this. There needs to be some kind of legislative decision making of sorts.
I think there should be, and I'm sure there have been. I mean, there are IP licenses, so I think there should have been this issue. Should have.
That's
Maybe it
something-
hasn't
That's
come
something
up
very
in that
peculiar about
sense.
IP in this country. We focus on temporary injunctions and we
No,
do not take
on-
things
yeah.
to court.
Fair enough. No. Agreed. But I think so. I think before even going to the, I mean, at least that's how I felt, because the public policy was one issue, but that I think is a slightly separate issue from how to deal with IP licenses generally. Of course, in a cross-border dispute, it will get even more complicated. So, yeah, no, but I mean,
We're just using
interesting
this
topic.
dispute to
But
like say ki there is a problem here.
yeah.
And have we identified it? If
No,
we
I
have,
think-
then look into it. If we haven't, tell us that we're wrong.
No, I think there is definitely an issue here. I think maybe the way to approach it is to first look dealing with it in a purely domestic situation before going to the cross-border angle, though of course that's also eventually will be relevant, hopefully, when if and when the cross-border law comes
Noted
in.
now.
But
We will take this into account.
I think Madam covered everything.
Mhm.
We have to look at this is a serious policy issue, and we have to consider it at least for the domestic point of view
But
first.
It's a connected problem, sir. As soon as we give some direction in the domestic issue, we will avoid Kimonda in India. Because if there's clarity on how we're treating our licenses, the courts will not have to subject their law, subject our proceedings to their law.
No, that's exactly the point. If there's clarity here, then if there's any I mean, we can say that, well, I mean, depending on which law applies, we'll have to deal. But if there is no clarity
Precisely.
in the domestic context, I think that's what
And
it is
bankruptcy in itself is a meta law, right? It affects everything from here to there.
We take some homework for us.
Sorry?
Is it the asset of the company?
It may be.
Maybe, or actually is the asset of the company.
Sorry?
IP licenses, where the company owns these licenses, it is an asset of the company.
It can be an asset, it can be a liability. Imagine if you are the licensor and you are licensing your intellectual property, there might come a situation where the contract is becoming very onerous for you. You're not gaining any money out of it, but the money is being drained from it, from your estate. At that point, it should become a liability.
And if it is a liability, it is a contingent liability during the CRP period.
I'm not particularly sure of
And
that.
if it is an asset, I can sell it with a bundle of the asset because it has a potential to sell it. And if it is a liability, it's a contingent liability, or it will be treated as all the contingent liability, the way other contingent liabilities are being treated. So where is the problem I am actually looking at?
No, so we're dealing with liquidation and CIRP.
Liquidation, we have a right that onerous property, if there is, you can terminate the contract.
No, but what does that termination mean? Like, will the
If it is
license...
no, every contract cannot be terminated during the liquidation. It has to be onerous. That is very difficult for the company that it cannot be continued. Right? Just because you have a power to terminate the contract during the liquidation, you cannot go it. Even as you said that during the CRP period, educating authority asked that. Talk with the creditors, because you have to be justified and reasonable why you are doing this.
Okay.
I am looking at the problem. I am not able to see where is the problem actually.
So, as soon as we come here, 1521, Article 2122, the court, like any foreign court, when they are giving us their assets, when they are allowing us to administer our proceedings to administer their assets, they will have to see how we are going to deal with those assets. Can we or can we not reject? If we can reject, what is the meaning of that rejection? And what we are saying is, we have no idea what the meaning of rejection
This is a cross-border issue right now.
Precisely.
Is it an IP issue or is it a cross-border
I
issue?
think the point here is that it's both. I mean, it eventually will come up in a cross-border issue specifically. But before we even go into the cross-border issue, we'll have to figure out how it's dealt with domestically. Because that will be relevant to, in a cross-border case, how the court will actually think of dealing with it. How does India look at these kind of contracts, right? I think that's what you're saying.
Yeah, I have got one question. In one of your slides, you are mentioning about India IBC adopting cross-border, in which you had mentioned that it is on a reciprocatory basis.
Yes, sir.
And as you also mentioned, you have studied US and UK and all, where they don't work on reciprocated basis.
Yeah.
How far this will be successful?
So this is beyond the scope of my study. I have not, I know that they are applying it on a reciprocal basis, but a value judgment, I am not equipped to make it here. That's all. Thank you.
Thank you, everyone. Now we can break for tea and coffee, which would be served outside. Thank you, everyone, for all your pertinent questions and for listening to the paper presentations carefully. Thank you to the panelists as well. Thanks a lot.